Okay, this week we're looking at our sexual assault crimes. And we're going to be covering several chapters as far as revised statutes of Missouri. As we go through this, most of them I've linked, and then I'll go through the chapter as we look at it. So for this week, we are going to cover Chapter 12 from the text, in addition to the Blue Book of Chapters 6, 13, and 16. So you're going to want to read these in addition to our lecture that we're covering over here. We're going to hit some other statutes outside of these three, but they're not going to be on your test. So one of the things that we want to look at is definitions when we start looking at any chapter, and I've talked to you about this before, that you don't want to make a mistake because you assume something and the definition for that crime or activity was actually different. So aggravated sexual offenses, when we start talking about aggravating and mitigating, as far as Missouri goes, serious physical injury, display of a weapon, sexual intercourse, or deviant sexual intercourse with more than one person. And you can read through these as far as what everything actually is. So commercial sex act, deviant sexual intercourse, forced labor, and then keeping these sexual conduct versus sexual contact versus sexual intercourse. So keeping those straight as far as exactly what they are. Sexual conduct basically is all of these together. So when we start looking at and start talking about those activities or looking at the criminal statute, that's what we're talking about there. Rape, anal, vaginal, or oral penetration by force or threat of force, sexual assault. The crime in most states, it includes the crime of rape as well as lesser degrees. Like we talked about before, those three definitions, which one are we looking at? Corroborative evidence, pornography, rape shield laws, statutory rape, incest, and then Megan's Law. When we start getting into RSMO, these will be in different chapters. Prostitution, procuring, promoting, or pimping, child pornography. And I put a list of these on your page as far as the class goes so that you can review these. So sexual relations become a crime in the United States if there's a lack of consent or they're conducted with a minor incapable of legal consent. Sex by itself is not a crime unless we start looking at how it was completed. So let's say they were conducted with a mentally deficient person, performed in public, performed for profit. There are certain relationships that can't have that, such as a therapist and a patient in violation of the law. And then we look at rape versus sodomy. Rape, first degree, if there's sexual intercourse with another person who's incapacitated and incapable of consent or lacks capacity to consent, versus sodomy, has deviant sexual intercourse. Well, we looked at that definition of deviant sexual intercourse from RSMO, and basically any act involving the genitals of one person, the hand, mouth, tongue, or anus of another. And then you can read through that definition, and the definition becomes important when we figure out which charge we're looking at or how has the victim been violated as far as the criminal activity. So rape or sexual assault. Historically, common law rape was non-consensual carnal knowledge. When you look at the definition of carnal knowledge, the easiest substitute for that is sexual intercourse by force or threat of force. Today, rape can be oral, vaginal, or anal, just like we looked at as far as the sodomy statutes. But again, according to your text, they classify it all as rape. But you've got to be specific when you look at your statutes as far as what you're investigating. In the United States, 1 out of every 6 women has experienced either rape or attempted rape at some time in their life. But at the same time, studies show that women who resist decrease the odds of completed rape by 80%, but they also increase the likelihood that they're going to be physically injured. So many states continue to use the term rape, but like I talked about in the last few minutes, is it rape? Is it sexual assault? Is it sexual abuse? What is your state statute say? And then just as we started looking at aggravating circumstances, and your text is pretty consistent with the RSMO, including multiple offenders, deadly weapon, causing pregnancy, transmitting sexual diseases, or the age of the victim comes into play. So the term sex crime includes a broad classification of offenses, and I'm going to show you that in just a minute, how big our sexual statutes are. There's quite a few. And then non-consensual sex is virtually always a crime. In addition, every state has statutory rape law under which the crime is to have sex with a child under a specific age, and we'll look at the age as far as Missouri goes. Other examples include rape, incest, sexual harassment, prostitution, voyeurism, exhibitionism, and child pornography, depending on one of these paraphilias that the person may be involved with. So as far as the elements of rape, it's gender neutral. It can be homosexual or heterosexual. What kind of coercion was involved? Was it physical force? Was it, a threat to reveal something? Resistance need only be communicated. Lack of consent and purely verbal resistance is sufficient. So if somebody just says no, or in another example, if they don't say anything at all, we should assume that that was not consent. So corroboration is not required in most states. It does make it easier for the prosecution in that if they have DNA, hair, or witnesses, it's going to be easier to gain that conviction, and they may be more likely to charge. Husband-wife exemption has been removed as far as can a person rape their spouse, and the answer is yes. And then prompt report rule has been relaxed as far as, a certain time limit. And then we have rape shield laws that limit evidence of past sexual conduct with that victim. And here's the link for our statute as far as revised statutes of Missouri. And it falls under prosecuting witnesses in certain cases not to be interrogated. And it talks about what can be used and what can't be used, and then when it could be used as far as 1 through 4 here. Evidence of sexual conduct of complaining witness offered in the section is admissible to the extent that the court finds the evidence relevant to the material or fact of the issue. It also goes through this: if the defendant proposes to offer evidence of sexual conduct of complaining witness under this section, they have to file a written motion accompanied by an offer of proof to get that into the hearing. So the defense is going to have to present some information to the court if they want to get that involved in that case. So non-consent. Consent is typically issued arising in rape cases. Again, rape, sexual penetration without consent. Without consent usually means forced or coerced. Victims expressed lack of consent. So like we talked about a second ago, the victim didn't say anything at all. It does not mean it's consent. Youth, the victim results in inability to consent. And then incapacity of victim. So drugs used like GHB or Hypnol, where the person cannot physically consent. That's definitely going to fall under non-consent. Mistake consent given. Because state must prove lack of consent, the issue of the presence or absence of consent is commonly raised. In most jurisdictions, all victims need to do is voice or show lack of consent, including inability to give consent. So again, if somebody's impaired through alcohol, through drugs, they definitely can't give consent. The use of force or threats generally negates consent. So if somebody's threatened with anything, physical force, blackmail, whatever, then that could be something that could show lack of consent. Some jurisdictions still define rape as requiring force as opposed to simple non-consent. And a person could be passively resistant. If that person, voiced an opinion that's, no, I don't want this to happen, but they didn't use force, that is a form of resistance. Even though it was passive, and we could still use that as when we're working that case as far as passive resistance goes. So rape shield laws, like we talked about, ours again is chapter 491, and you can read through that again. Laws have been passed in many states to limit to extent. So however, evidence may be admitted if past sexual relations between the victim and the defendant on issue of consent. So if that suspect and victim have had a relationship in the past, that may be entered in certain situations. Evidence of sex with another person, but only to prove defendant was not source of semen found on victim. And then evidence of prior false reports. If the victim has filed false reports in the past, that may get brought into that case. So statutory rape, sexual relations with a child under a specific age, usually 16, Missouri it's 14. is a crime even if done with consent. Under our statutes, child molestation, first degree. A person commits the offense of child molestation in the first degree if he or she subjects another person who is less than 14 years of age to sexual conduct, and the offense is an aggravated sexual offense. As far as child molestation, second degree, a person commits the offense of child molestation in the second degree if he or she subjects a person who is less than 12 years of age to sexual conduct, being more than 4 years older than a child who is less than 17 years of age, subjects the child to sexual contact. And the offense is an aggravated sexual offense. So reading through those statutes, then child molestation third degree, a person commits the offense of child molestation in the third degree if he or she subjects a child who's less than 14 years of age to sexual contact. Again, we're still talking about a Class C felony. And Missouri has a child molestation fourth degree. And a person commits the offense of child molestation in the fourth degree if being more than 4 years older than a child who is less than 17 years of age, subjects the child to sexual contact. So we've got a 16-year-old that a 22, 23-year-old was involved with. We can have that child molestation in the fourth degree. And there we're talking about a Class E felony. In this section right here, sexual misconduct involving a child as far as penalty, you may want to pay special attention to that one. In that the subject knowingly exposed his or her genital to a child less than 15 years of age under circumstances which he or she knows that his or her conduct is likely to cause affront or alarm. So this is somebody that exposed themselves to children for their own sexual gratification. When we're looking at that, arousing or gratify the sexual desires of any person. So this is something that you could get a call on or be working that case that a person may argue that it was an accident, but you have to look at, what was that person actually trying to do by exposing themselves. In most cases, if the defendant argues that they believe the person was a certain age, it's not going to be a defense. So some mistakes could be, but typically the defense depends on the declaration of age by the alleged victim. And then what does the victim actually look like? If they're under a certain age, depending on what state you live in, there's going to be no defense. So, failure or delayed reporting. In some cases, people may not want to report that for fear of retaliation by the offender. They may be ashamed, or they might not think it's just a police matter at that point. But later on, they come in and they want to file that report. And this could be years later, depending on what the statute of limitations are on what they're reporting. So, link right here, statutory rape laws by state. You can click this and look at it. So, as far as incest goes, it's estimated that there's 60,000 to 100,000 female children who are sexually abused annually, and 80% of sexual abuse is not reported. So, it's believed that incest affects more than 10% of all American families, with at least 5,000 cases of father-daughter incest yearly. That's a substantial number when you start looking at this. And then how many times was the victim offended on? Crime of incest may be committed by adults within a family, any family member, but the public concern and prosecution are generally for cases involving children. When we start looking at the incest statute, for Missouri, it reads, a person commits the offense of incest if he or she marries or purports to marry or engages in sexual intercourse or deviant sexual intercourse with a person he or she knows, so that we actually have to have a culpable state of knowingly, to be without regard to the dignity of his or her ancestor descended by blood or adoption, stepchild while the marriage creating the relationship exists, brother or sister of the whole or half blood, uncle, aunt, nephew, or niece of the whole blood, and then it's a Class E felony as far as that occurring. And after looking at the statute, like statutory rape, the crime does not require showing that force was used or threatened, or that the victim did not consent. However, we do have to prove that relationship existed and that the person knew it, depending on which state statute you're reading. I've provided a link on there for this website, Survivors of Incest Anonymous. It's an interesting website in that normally we would have a discussion of why we need this type of a service, but obviously we do have issues based on the statistics we've been talking about. So I provided it here for you to provide to somebody else or to use in your own research. Okay, HIV and AIDS-related crimes. If you were alive during the 80s and 90s, there was widespread fear. Several, high-profile people passed away due to HIV/AIDS, and so some criminal laws were enacted, basically to help stop the spread of the disease. And knowingly or recklessly or negligently exposing or infecting another person to AIDS was considered a felony. And here's Missouri's statute as far as exposing that person. And we look at the dates when this bill was first brought up, and we can see 1997. So pretty consistent with what we're talking about in our discussion today. Further, laws that require registration for sex offenders. Most states have registered laws like Megan's Law for convicted sex offenders, and Missouri does have one of those. And that falls under Chapter 589, registration of certain offenders with Chief Law Enforcement Officer. So when we start looking at these chapters, that's what we're actually seeing of where these people have to register, under what conditions they have to register, and then giving some descriptions. And this is a fairly in-depth statute as far as who has to do what and when. So then we have our sex offender registry for the state of Missouri. And if you're not familiar with this, it's run by the Missouri State Highway Patrol. And the link will take you to this website. You do have to click that you agree. And then you can start searching by your area as far as offenders, who is involved, and how to find out, as far as notifications, statistics, different fact sheets, all again that are provided by the Highway Patrol. Initially only the worst sexual offenses were listed. So now the trend to include almost all sexual offenses, and that has changed depending on what state you're in, which ones that they have to register for, which ones they don't. And under most state systems, persons required to register are also prohibited from certain actions. They can only live a certain distance to a school, daycare, park, depending on what the statute is. And usually they're required to provide photographs, DNA samples, addresses, telephone numbers, where they're driving, descriptions of vehicles, information that they can be used to keep track of these individuals. So in some states, laws permit the state to obtain civil commitments. So basically, they would go from a prison system to, what would be considered a hospital, but it's going to be a lockdown facility, in that it's going to be very similar to a prison system, but it would be considered treatment over actual lockdown. And this is one of our statutes as far as, when a person could be, sent to one of these facilities, and how that would go about. When we look at civil commitment, we have to show the person is dangerous sexual predator, who poses a substantial threat to commit sexual offenses in the future, and the big one, can't control his or her behavior. Once these people are committed, most are never released. So, prostitution. Every state of Nevada makes prostitution a crime, and not every county in Nevada actually allows prostitution. Prostitution includes engaging in sexual relations with another person for a fee or something of value. It doesn't have to be money. Offering or soliciting to engage in sexual relations with another person for a fee or something of value, and or requesting. So both parties, the person offering and the person requesting, can actually get in trouble for these type of crimes. Pandering is a charge brought against the person who entices another to become a prostitute or maintains a public place where prostitution is practiced. In many states, a crime called debauching a minor to entice a person under the age of 70 to have sex with a prostitute, and sometimes any other person. So, other crimes: sexual contact without penetration, sexual touching, generally requires to show the state that touching was done on sexual or intimate parts for the purpose of sexual gratification. You may get cases where somebody alleges that a person touched them where they shouldn't have, but the defense is that they didn't mean to. One I've heard in the past is, they were wrestling or whatever else. You have to look at the case as a whole to figure out whether you believe the person or not. Lewd or lascivious conduct or behavior with a child statutes often require showing the defendant had specific intent to arouse or gratify either their self or the child's sexual desires on their own. So, Child pornography is treated differently from adult pornography. Adult pornography is sold openly to the United States. Child pornography is outlawed by the federal government. Unlike adult pornography, child pornography need not be obscene to be criminal. So when we start looking at the pornography, what are we seeing and why is that being put out there? The mere fact that a child is involved in such conduct is enough to make the practice a crime, and it's not protected by the speech or First Amendment. So child pornography that is obscene under the standard First Amendment obscenity test can be made criminal whether or not actual children are even involved. So if somebody does drawings or something like that, we may be able to prosecute those under certain statute. Possession, production, sale, usually called trafficking or solicitation of child pornography, is a crime. And then prosecutions for child pornography have increased definitely because of the internet, as far as what's out there, where people are getting it. Now, there's certain organizations that do track this as far as their criminal investigations and look at those prosecutions on how they get these individuals. Okay, let's look at invasion of privacy. So peeping toms, people who sneak around, look in windows, people that put cameras where they shouldn't put them. There's laws now that look at this. Missouri statute, invasion of privacy. A person commits the offense of invasion of privacy if he or she knowingly photographs, films, videotapes, produces, or otherwise creates an image of another person without that person's consent while the person is in a state of full or partial nudity, as in a place where one would have a reasonable expectation of privacy. So when we start looking at this statute, it goes along with our text as far as people doing the crimes of upskirting or down blousing would definitely fall under our invasion of privacy statutes. Okay, that is the end of this chapter. Remember, not only will you want to read and follow our lecture, but read through Chapter 6 as far as sexual offenses, Chapter 13 as far as the Blue Book, and Chapter 16. Further, a lot of these offenses are listed in your Blue Book, but Chapter 566 is your sexual offenses as far as rape, sodomy, child molestation. When we look at Chapter 589, sexual assault prevention, this is where we start talking about registering our sex offenders, and here's Megan's Law. Then again, your highway patrol as far as your sex offender registry if you want to research your area or that of another person. And then procedures when we looked at as far as how we would get a person into a cell. And also on Chapter 568 as far as incest, and then like we covered in our last, as far as assault, endangering the welfare of a child, abuse, genital mutilation. So quite a big chapter that you're going to be looking at going through this week. So you will want to review. I will tell you that you get 3 attempts on this test. So take your time with it, follow along, and we will be switching chapters next week.